Here to discuss Teleservices Compliance 2017 is Michelle Schuster, partner with McMurray, Peterson & Schuster, LLP. Please give her a warm welcome.
It's a pleasure to be with you here today. As you heard, I'm Michelle Schuster. I'm with the law firm of McMurray, Peterson & Schuster. We have been together as a law firm for 10 years now. Prior to that, I was at a big law firm in Columbus, Ohio. And before that, I was the chief of Ohio's Consumer Protection Section in the AG's office. And during my time at the AG's office, I worked on the state and federal level to assist with the passage of do not call laws. So as a result, I've found a career in assisting companies with compliance with telemarketing and teleservices regulations. It's a pleasure to be here with you today to talk about a very important topic, the Telephone Consumer Protection Act, and ways that you can comply with its requirements and really protect yourself from some of the harsh realities of the TCPA today with class actions and regulatory enforcement. So today we're going to talk, as I said, about the Telephone Consumer Protection Act, or abbreviated the TCPA. I'm going to give you an overview of the TCPA's provisions, and specifically we're going to be focusing on calls and texts to cell phones, touching a little bit on some of the other areas of the TCPA. I want to talk about vicarious liability, or how you can be liable when you hire others to call or text on your behalf. And then we're going to conclude with talking about some specific compliance challenges and how you can mitigate those challenges. While we will be talking about legal topics throughout this presentation, it's really important that you consult with your own legal counsel on specific issues related to TCPA compliance. It is a very tedious regulation that has details and nuances which are important to consider when determining how to comply with the TCPA. So I really encourage you to consult with your own attorney. So let's talk about the basics of the TCPA. As I said, we're primarily concerned today about calls or texts to cell phones, but also understand that the TCPA has prohibitions without the right kind of consent against pre-recorded messages, and also faxes. I will tell you, I get about one new fax case a month into our office, and I am always surprised at how many companies are still using faxes. We're not going to go into the details today, but I think it's important that you realize if you're sending faxes, whether it's for sales purposes or even just for transactional purposes, there are specific requirements for faxes. Make sure you understand those requirements before you send any type of fax. You are required to have specific disclosures, and there are consent requirements around faxes. Also, do not call laws. I know that dealers are very familiar with the do not call laws. They've been around since 2003. We're not going to spend any time today talking about those, but it is very important that you understand we're only talking about the calling and texting to cell phones issue today. All of these other regulations, in particular do not call regulations, still apply. So once we get done with our analysis of how we can and if we can call or text cell phones, we then need to look at all of those other regulations. We're not going to talk about those today, but understand that they still apply. There are other provisions in the TCPA that have to do with time of day restrictions, required disclosures, accepting internal do not call requests. Again, these are all components of the TCPA that you need to understand that we will not be going through today. In the footnote at the bottom of this slide, you see that the TCPA applies not just to business-to-consumer calls, but also business-to-business calls. Really, the prohibition against calls and text to cell phones apply to all calls. So don't think just because you're making a business-to-business call that you don't need to worry about the TCPA regulations. And unlike do not call regulations, this part of the TCPA regarding calls and text to cell phones also applies, as I said, all calls, including non-marketing calls. So think about this TCPA compliance in this area as broadly as you can imagine. The TCPA is enforced by the Federal Communications Commission, and it has the ability to level civil penalties. And at the time the slide was made in the fall, that amount was $16,000. It's now up to $18,000+ per violation. And there's a private right of action that allows for $500 to $1,500 per violation for a private plaintiff or class action attorney to sue under the TCPA. And when we say per violation, I'm not talking about a calling campaign, I am talking about per call. And if you think about the number of calls that are made in your dealership potentially to cell phones on a daily basis, and you multiply those for a civil penalty at an $18,000 multiplier or a $1,500 multiplier for private rights of action, that number gets huge very quickly. And considering that the statute of limitations for TCPA calls can go back 4 or 5 years, then that multiplier becomes huge and quickly larger than I can calculate on my calculator. So this is a real issue that has some serious ramifications and bet your business kind of ramifications. So it's something we really need to pay attention to and understand. The purpose of my presentation today is to really highlight the important issues with compliance that you can take care of so that you can mitigate this risk and sleep easy at night, knowing that you're doing everything that you're required to do. The difference in the private right of action, I will tell you, between the $500 and the $1,500. $500 is the base amount. That is trebled to $1,500 if the calls are, if they're willful calls or willful violations of the TCPA. And I can tell you that if you're making a telephone call, the FCC and the courts are going to see that as a willful violation with some very limited exceptions. So the $1,500 is generally what we're looking at per call. There is strict liability for every call that your dealership places itself. So calls by your sales agents or calls by marketers within your sales organization. There is vicarious liability, meaning that you can be liable if you hire a third party, maybe a telemarketer or a texting platform of some type to place calls or texts on your behalf. You can be vicariously liable even though you're not the one who actually called or sent the text in certain situations. And we're going to talk about that in a little bit greater detail later in the presentation. Also, no, there are no caps on damages. If you deal in the Fair Credit Reporting, Fair Debt Collection Practices Act, a number of those types of regulations have caps on damages. There are no caps here. So when I say the multiplier becomes huge, that is a huge uncapped multiplier for damages for violations. The TCPA filings back in 2015 were about 3,800 on the federal level, even more on the state, even additional cases on the state level. 2016, it was at or above 6,000. We're looking at the final numbers now. So these are a huge amount of cases that are filed. It is now the second highest filed action in federal court behind debt collection actions that are filed in federal court. So this is not a one-off type of issue. This is something that there are a number of lawsuits that are being filed. The reason TCPA actions are so popular is because, as we've talked about, there's no cap, the multiplier is huge, and in addition to that, consumer class actions can be filed. Generally, these campaigns, without going into a lot of details, can meet the class certification requirement because all of the calls are generally the same and the same set of facts are applying to those calls. There are a number of exceptions to that, but generally these are filed as class actions. So it really becomes a very large issue to deal with should you run into compliance problems. I'd like to start off by, so you know that you're not alone and you see how widespread this is, with a video about an issue that the Lakers ran into with the TCPA.
On their home court at the Staples Center, the Los Angeles Lakers are known for giving their fans showtime, exciting basketball. But now, one fan is giving back to the team, a class action lawsuit that is, and it could cost them tens of millions of dollars. Like most teams, the Lakers use social media to enhance the fan experience. Here, the Lakers asked fans to vote by text message for their favorite song to be played during timeouts. But it was the responding "thank you" text that sparked the lawsuit. That single response text, say the plaintiffs, is a violation of the Federal Telephone Consumer Protection Act, or TCPA. Businesses making unsolicited phone calls to customers face a fine of up to $1,500 per call. And yes, the plaintiffs allege that a text is technically a phone call.
When the TCPA was created in 1991, there were no text messages. There weren't smartphones. There weren't these kinds of technologies.
Becca Walquist is an attorney who deals with TCPA lawsuits. She says plaintiffs take advantage of the combination of an old law and new technologies to bring lucrative suits.
Companies who are using these sorts of technologies are finding themselves subject to lawsuits for a statute they may not have even really known could apply to them.
Many other companies are threatened with mega litigation over texting that most customers actually like pharmacies texting reminders to customers that it is time for their flu shot, or insurance companies texting information on how to quickly file a claim after a natural disaster. Where most see these texts as helpful, some see an opportunity to litigate. In the Lakers case, the statute of limitations goes back 4 years, and the plaintiff is putting his fellow fans into this class action lawsuit to magnify the potential damages. A virtually identical lawsuit against the LA Clippers basketball team was settled last year. Whatever the outcome, the cost of defending lawsuits like these will likely be passed on to the future LA fans, leaving many LA basketball lovers crying foul. For more stories, visit facesoflawsuitabuse.org.
So as that video illustrates, it's not just the entrepreneurial type companies that are struggling to deal with these types of issues. It is the large companies. It's the Fortune 500s that are even struggling to comply with TCPA requirements. The slide in front of you now is just an illustration of how far-reaching TCPA lawsuits have been. I think the largest on there is $75 million, which was a settlement that was reached with the bank. But you'll see there's auto dealerships in the $5 million range that have settled TCPA class actions against extended automotive warranty services or service contracts, another area where plaintiffs, class action attorneys have been focusing their efforts. So this is an area where I cannot stress enough that an ounce of prevention is worth a pound of cure. As I said, this is we've seen an increase in lawsuits, and I'll tell you why we see the numbers to really start spiking in the 2012-2013 time frame. When we get into the details of what you're required to do under the TCPA, prior to 2013, and this was announced in 2012, there was an exemption to these TCPA requirements for calls and texts to cell phones if you had an existing business relationship with the person that you were calling. And this probably sounds familiar to many of you that have been in the industry for a while. Well, that exemption went away in 2013. So consumer class action attorneys became aware of the use of the TCPA as a way of filing a significant lawsuit that results in a significant amount of attorney's fees. And they became aware of that in the 2011-2012 timeframe when that exemption went away in 2013. So that's why we've seen such a large uptick in these TCPA filings. So let's talk about the rule now. Before I do that, I want to go back to something that the attorney in the Lakers video mentioned. She mentioned that the prohibitions in the TCPA are the result of a law that was passed in 1991. And that is absolutely true. The TCPA prohibitions against calls to texts and cell phones were in 1991. And you got to kind of understand what the industry was like in 1991. I don't know about you, but back in 1991, I had one of those bag cell phones that I would carry around. You'd have to have an antenna on your car. And if I wanted to use that cell phone, those minutes would cost me somewhere between $3 to $5 per minute. So we only gave that cell phone number out sparingly, and certainly didn't want unwanted calls on that cell phone. So that was one thing that was going on. Also, and I will tell you, I'm general counsel for PACE, the Professional Association for Customer Engagement. We are the trade association that represents contact centers, including inbound and outbound telemarketers. And the industry would be the first to admit that back in the early 90s, there were some abusive practices that were happening in the telemarketing world, in that people were doing something that was known as random or sequential dialing. So what is random or sequential dialing? Random dialing is when you'll load a phone book into a dialer and you just start calling all of those numbers in the phone book. It's cold calling at its worst. You don't have connections to most of the people that you're calling. You use dialers that hang up as much as they would actually connect with live individuals. And it was pretty much the wild, wild west of dialing. In addition to that, you could sequentially dial, which is mean the integer, last integer or integers in the phone number would increase, and you would just dial in that sequential fashion as many telephone numbers as you could. Imagine what happens when you do that. First, you're going to call people with these cell phones that were being charged $3 to $5 a minute for their minutes. You're going to call a company like IBM that has hundreds of phone numbers in their large offices that are increased by integer. So you have now shut down every phone call or every phone in IBM because they're receiving a telemarketing call. Or worse, you're calling into a hospital that has those types of sequential numbers, and you've now shut down every phone in that hospital. On top of that, you know, the complaints about calls at dinner time, late at night, early in the morning. You know, this was an unregulated area, and those types of things were happening. So the TCPA was in response to that abusive type of dialing that some of the sponsors of the TCPA called the scourge of modern society. And so the words that we have in the TCPA were meant to be very strict and we're meant to stop that type of calling. The good news is it was effective. We don't randomly sequentially dial anymore, and now marketing campaigns are pretty targeted. It's an expensive prospect to market, so we make sure that we are calling people with whom we have a pretty high likelihood of success of making some type of sale. So understand that as we're talking about the rule, and it will make a little bit more sense. So the rule. The rule is you cannot use an automatic telephone dialing system, or an ATDS, and I'm going to use that acronym a lot. So ATDS is automatic telephone dialing system, or a pre-recorded message, so either of those two things, to call or text a cell phone without the called party's prior consent. There are two levels of consent for a transactional call, so something not involved in sales or the attempt to make a sale, you need prior express consent. If it's a telemarketing call, that consent has to be in writing. And I'm going to go into a lot of detail here in a second in those two types of consent. The thing you need to know first of all is if you're not using an ATDS or a pre-recorded message, we don't have to worry about these consent requirements. That's not a very easy determination to make, though, and we're going to talk about that. If it's a mixed purpose call, meaning let's say that you're calling a customer to let them know that their car is ready to be picked up from your service department, but you also want to let them know that you're having a discount on oil changes. And if they want to, they can get an oil change at the same time. Well, that initial call, that their car is ready, it's transactional. You would only need prior express consent. As soon as you throw in that upsell for an oil change, it's become a marketing call and you need prior express written consent. So understand those dual purposes calls. If there's a marketing component, it becomes telemarketing. And again, it applies equally to business to consumer calls as it does to business calls. You know, before we go off that slide, you might be thinking back in 1991, we weren't texting. There was no such thing as a text back in maybe Al Gore was texting back in 1991, but the rest of us were not texting yet. That really hadn't been created as a platform. I will tell you that the FCC, through its declaratory rulings, has said that a text to a cell phone is the exact same thing as a call to a cell phone. So I'm not going to keep saying call or text to cell phone throughout this entire presentation. When I say a call to a cell phone, understand it applies equally to texts. So again, two different levels of consent. Here are some examples of non-marketing and marketing types of communications. So let's go back to that ATDS that we put a bookmark in just a minute ago. So there's a definition contained within the TCPA of what an ATDS is. It's equipment that has the capacity to store or produce telephone numbers to be called using a random or sequential number generator and then to dial such numbers. So two requirements in that definition of what an ATDS is. But I want you to kind of focus on that word capacity because it's not defined in the statute, and it has become the source of a lot of controversy, and I don't think we yet to this day have a good definition for capacity, but we are going to spend some time talking about that. So if you look at the statutory definition of an ATDS, it kind of makes sense when you understand what was going on in 1991, but the statute has not been modified since 1991, but what has happened is that the FCC has authority to implement rules to provide meaning and to allow the TCPA to stay up with modern times. And they've done that on several occasions. And as it applies to what we're talking about today, in 2003 and 2008, they issued what they call declaratory rulings, and they expanded the definition of an ATDS to include some more modern inventions and not just these random and sequential number generators. Basically, what they said is the prohibition here, or what the ATDS is meant to be that they're prohibiting, is anything that dials without human intervention. And they specifically looked at something called a predictive dialer, which is a dialing system that dials phone numbers for the agents. And when they connect to a human being, it's connected to the agent. It allows the system to use algorithms to predict how many people are going to answer those phone calls. So I may only have 10 agents available in my call center, but I can place 20 calls because I know only half of those are going to be answered. So the FCC went in and said that a predictive dialer has that same fundamental use as random and sequential number generators, and that it can dial a large number of people in a short period of time without human intervention. So it expanded this definition of ATDS. And that's when that word capacity became problematic, because most companies that are using the phone as a significant means of contacting consumers for sales or even for transactional calls use dialing systems that have built into them the ability to predictively dial, because it's an efficient way of contacting people. So as General Counsel for PACE, we filed what's known as a petition for declaratory ruling with the FCC, and I'll tell you, be careful what you ask for. And we wanted them to give us a definition of capacity. What does that mean? Is it the capacity of the system at the time it's dialing? Because with those preview dialers, I can turn that preview mode off and use it to, with predictive dialers, I can turn that predictive dialer off and use it to preview, meaning that my agents don't have to dial all 10 digits. They can push a button and the system dials the 10 digits for them. It's called preview dialing. I have dialing systems that, while they can't predictively dial now, that system is meant to be scalable. So I could purchase software or an additional license and turn my dialing system into a predictive dialer. And so does it mean that that system has the capacity because I can purchase those types of things? Or is it just some type of future theoretical capacity, which of course we didn't opine about when we were asking the FCC. So as I said, be careful what you ask for, because we, along with the other associations and companies that asked for clarity around this definition of ATDS, got our answer in July of 2015. And they defined that word capacity as potential ability to function as an ATDS. So it doesn't have to be doing that as it's dialing currently for a campaign, but just if it has the potential ability to randomly, sequentially, or predictively dial, or dial from a list without human intervention, then it's an ATDS. And they said that that can even be with the addition of software. So that example I gave of updating a system by adding software or purchasing a license to be able to use certain functions within that dialer, that would be an ATDS. The FCC said that is an ATDS. They gave no definitive guidance. The best they could say is that a rotary phone is not an ATDS, but they said that a cell phone could be an ATDS because it has the ability to download an app that would allow the person with that cell phone to call from their contact list, or even to connect with the dealership's CRM and dial from that list. So if a cell phone can be an ATDS, then all of a sudden we dealerships have an issue with every call that our salesperson makes from their cell phone unless we take precautions. So that's why this issue has become an issue for so many companies, because even a desk phone that has modern technology associated with it, meaning that it might just be connected to a computer, you can download software to that computer to potentially turn that phone into an ATDS. So it's not an easy determination to make. Some practical considerations. You have to take into consideration the system's capacity, regardless of how it's used. I think we've already talked about that. And if you can modify the system to turn it into a predictive dialer or some other type of automated dialer, then it's going to be considered an ATDS. Most call centers are going to have predictive dialers because you can still use those to call landlines. The prohibition, remember, is just against calls to cell phones. If you have a predictive dialer on your system, or in-house, you have to segregate those. You can't use the same servers, or it might be considered one system. So lots of things to consider. The net of all of this is it takes an expert to look at a system to be able to determine if it's an ATDS, and I highly recommend that if you are relying on a system to manually dial, and you want to do that so you don't have consent, you get an expert to come in and document your system's capacity. Because what happens in these scenarios is that a consumer class action attorney will send something that's known as a notice of consent to sue, or I'm sorry, notice of intent to sue. And when they send that letter, they say, you've called my client. We heard a delay in the phone when it called, therefore we think you're using a predictive dialer. He didn't give you or she didn't give you consent to call them, therefore you have violated the TCPA. And we believe you made more than that one call to our client. We believe you've been making all your calls like that, therefore we will be representing a class of individuals in a lawsuit against you unless you can prove, one, you didn't use an ATDS, or two, you had consent to call that person. So just focusing on the ATDS issue, you get that to go away if you have very good documentation that says your system is not an ATDS and the call was made manually. So it's really critical that you document that. I will tell you, one of the first cases in this area that was decided after the 2015 ruling was against Yahoo. And Yahoo was pretty convinced that they were using a manual dialing system until their IT person got on the stand and said, as I'm sure your IT people who are very smart would also say, they could make anything dial in a predictive, random, or sequential way. So any system they could do that to. So it was on a summary judgment motion that the court couldn't dismiss it because now their own expert had said that he could change this to make it into an ATDS. So critically important that your own IT people believe that your system is not an ATDS, because in the end it becomes a battle of the experts on what is or is not an ATDS, and you need a reliable expert and a staff that believes that your system is not an ATDS. Those things have to be documented before you have any types of issues. Okay, so let's say that we have decided we are not going to try to dial with a manual system. We either think, one, there's too much risk, or two, we want to have the efficiencies that are built into these modern dialing systems so that we can ensure compliance by putting calling time restrictions and putting in specific state requirements into our CRM, some very helpful functions that are in these modern dialing systems that you may want to take advantage of. So now what do we have to do? As we said in the beginning, we have to look to consent. There are two levels of consent. Prior express consent for non-telemarketing calls. It has to be in writing if it's a telemarketing call. As might be a theme that you're picking up on now, the FCC is not real great at guidance at all times. And the TCPA, not great at guidance either. And prior express consent is one of those areas where we don't have great guidance on, because while it's required for non-telemarketing calls, it has not been defined by the TCPA. There is no definition of the TCPA. So the FCC has given various rulings that have tried to clarify what prior express written consent is, but this is what you can safely rely on, that if a person has provided you with their cell phone number in the ordinary course of business, and you're calling them in the ordinary course of business, then you have prior express consent. So some examples in a dealership would be somebody has dropped off their car for service and you want to call them back to let them know that their car is ready, and you ask that person, the consumer, for their telephone number and they give you their cell phone number, then you now have prior express consent to call them to let them know their car is ready to be picked up. So that would be a good example of prior express consent. You can get consent through intermediaries too. So let's say, for instance, that your customer has dropped off the car and she said, my husband's going to pick it up at the end of the day. Don't call me, call him, and here's his cell phone number. Generally, you can rely on those types of things. So the FCC has said that those types of things are things you can rely on. The courts have overwhelmingly deferred to the FCC on this, so that is something that you also can rely on. And without going into a tremendous amount of detail on what prior express written consent is, these are the factors that have to be in any type of prior express written consent. Obviously, it has to be a written agreement, But the e-Sign Act, which is federal law that says that you can authenticate a writing through other things than just a written pen and ink document, such as online verification or a recorded voice call, so getting consent over the telephone, those types of things would be sufficient for a writing. So if you're complying with e-Sign, it works here for a written agreement. You have to identify the specific person or company that's getting consent to place that call to someone's cell phone. So for your dealerships, you'd want to identify your dealership specifically. The consumer has to provide their telephone number, and they have to take some type of affirmative action. So if it's just a writing, obviously the writing would be the affirmative action. And if it's an online generation form, frequently check boxes are used, but there are other ways you could get consent without a mandatory checkbox. Not as obvious, though, are some of the disclosures that are required in this, in the language used to get prior express written consent. You have to identify that the consent is being given for a telemarketing call using an automated dialing system, and that their consent is not required for purchase. So when I say all three of those things have to be in there, they absolutely have to be in there, and you have to save that document for at least 5 years is our recommendation, so that you can prove that you had consent to make telephone calls. They have to be clear and conspicuous. I'm not going to go into a lot of detail with this because I highly recommend, if you are relying on consent to make these telephone calls, it has got to get approval from your attorney, because there are lots of traps here for the unwary or some other type of compliance professional. But generally, I can tell you this is the type of language that we're looking at. So if it's online, you could do something here. I have a checkbox that somebody could check online that says, yes, please contact me at the above phone number regarding your dealership's products. I understand that automated technology and pre-recorded messages may be used, and the consent is not required to make a purchase. So that's the type of stuff that we're looking for consent language. There's an example of a script here that I won't read, but it's there, and it's got that same general content for getting prior express consent. All right, so just to recap, so we know what we're doing here before we go into kind of some of the exceptions to the rule or the additional concerns that we have. The TCPA prohibits calls or texts to cell phones using an ATDS without consent. So you either need to not use an ATDS to call these cell phones, or if you're using an ATDS, you have to have consent. So that is the basic rule. That's fundamentally what you need to understand. Okay, so unfortunately, though, that's not the end of the story. There's other things we need to worry about. That declaratory ruling in 2015 that I discussed earlier, it had some additional components to it as well that the FCC put the industry on notice about. First, with regard to consent, once consent has been given, you can rely on that up until the point where it is revoked. And the FCC said that consumers can revoke consent in any reasonable way. Reasonable, obviously, up to interpretation, but they did give examples that it could be just in any unilateral way from the consumer, including a good example for dealerships would be on a busy Saturday morning when you have hopefully dozens and dozens of people in your dealership and the phones are ringing and your receptionist is busy and everybody's busy, and you've got a consumer who's likely a professional plaintiff that comes into your dealership and tells that busy receptionist, I don't want you calling me on my cell phone anymore, here's my cell phone number. And then they spew it out. The FCC has said that that could be a reasonable means of revoking consent. So you have to have training for your employees so that they can know what to do if somebody comes in and says something like that, because your receptionist is going to want to stop at that person and say, hey, wait a minute, I need to record this. I need to get your information. Please give it to me. And then the receptionist is going to need to know what to do with that. Same with your salespeople. So this is definitely worth a few moments of training with them. But then more importantly, once they get that consent or that revocation of consent, you have to update your system so you stop calling them. And as soon as the consumer has revoked consent, it is effective. It's not like an internal do not call request where you could have up to 30 days to honor that request. At the second of revocation, the consent is gone. And then you're going to want to make sure that you maintain proper business records. You know, I haven't talked about this yet, but underlying all of these things that I'm talking about is the thought that you need to have compliance manuals and you need to have documented policies and procedures for how you're going to comply with the TCPA, and revocation of consent is definitely one of those types of areas. Another issue that came up, and this was also in that declaratory ruling, is reassigned numbers. So you may not be aware of this, but there are a very large number of cell phone numbers that are reassigned on a monthly basis. We're talking about hundreds of thousands of calls on a monthly basis. Generally, these types of, well, there's a number of different reasons for reassignment, but I will tell you in the debt collection space, this is a particularly difficult issue because it seems that people who owe debts and are getting debt collection calls are more likely to give up their cell phone number as a means of stopping those calls. So the issue with reassigned numbers is that, let's say we've done everything right, we've gotten consent, you've given me consent to give you a call, but now you've given up your phone number for whatever reason, and it's been reassigned to Sally over here. So I'm calling thinking I'm calling you, but actually I'm reaching Sally. I had consent to call you, I didn't have consent to call Sally. Excuse me. And what the FCC has said is that the consent goes to not the intended recipient, who is you, but to the person that is actually called, which is Sally, who I didn't have consent for. So I have now violated the TCPA because I meant to call you and I called somebody to whom I did not, or for whom had not given me consent. This is probably one of the most significant problems I have with the 2015 declaratory ruling because there is no way to comply with this section. There is no list of numbers out there that tells me a number has been reassigned. So I can't scrub against a list and say, well, this is a reassigned number. I have no way of knowing. The FCC realized this in their declaratory ruling, so what they said was, we're going to give you a safe harbor to call one time. So I can call you one time and Sally can answer and I haven't violated anything. You don't have to have picked up the call. I don't need to have heard a voice recording that said I have reached a different number. I don't need to have gotten a tritone. Nothing could have put me on knowledge that I've called the wrong person, not even a voicemail that says that it's Sally. But just the mere fact that I placed the call and it went to Sally, the second call I make that goes to Sally is going to be a violation. I will tell you that with the declaratory ruling, it's on appeal. We and a number of 8 other petitioners filed an appeal regarding the FCC's declaratory ruling, and this case had oral arguments in October, and the court, as they were hearing oral arguments and with the questions that they asked, had particular trouble with this issue of reassigned numbers, especially for text messages. I mean, you might be able to get notice through a voicemail message or, hey, you've got the wrong number, Michelle, stop calling me, I'm Sally. That type of thing might put me on notice, but for a text message, there's just not any of that type of interaction that would put you on notice. So I'm going to talk about what I think is going to happen with that appeal, but I think that that's a significant issue that the FCC has to deal with. There are some limited exemptions, not really so relevant for what we're talking about here. So as I said, the FCC's declaratory ruling from 2015 that really mucked up what the definition of an ATDS is based on capacity and these other issues with revocation of consent and reassigned numbers has been fully briefed. The oral arguments have happened already, and we are likely to get some type of decision in the spring of 2017. I'm not one to predict what the likely outcome of that is, but some of the some of the outcomes potentially are that the DC Circuit Court of Appeals could say they agree with the FCC and everything's agreed to. That gives the petitioners the ability to appeal. They could agree with us, and that would give the FCC the ability to appeal. The court could also say that the FCC acted in a way that was arbitrary and capricious, and they could send it back to the FCC to try to fix some of its rulings. That would be a good outcome in my mind. With the election of President Trump, regardless of what your politics are, the effect of that is that he will be selecting the majority of commissioners for the FCC. So we'll have 3 Republicans and 2 Democrats. When the FCC declaratory ruling was decided, it was 3 Democrats, 2 Republicans, with the 2 Republicans dissenting. Those 2 Republicans are still at the FCC. One is now just recently been appointed the chair, and he put a dissenting opinion out with that declaratory ruling that basically disagreed with almost everything that the majority of the FCC put into that declaratory ruling. So I am hopeful that if that our appeal results in it going back to the FCC, that we'll have some more common sense guidance and the ability for companies to actually comply, because let's face it, you guys want to comply. You don't want this uncertainty. You want to know if you're using an ATDS, and you want to know that consent has been revoked, and you want to know you're calling the right phone numbers. So I'm hopeful that, that if it does, that the appeal will have that effect and we'll get some more common sense rulings out of that. All right, so that's primarily what we want to talk about with the TCPA prohibitions and the main issues that we face. As I've mentioned, there are a whole host of other rules that apply. The red note at the bottom of the slide is important. There are 12 states that have prohibitions against calling or texting cell phones that are different than the FCC's prohibitions. Some of them don't look at whether you've used an ATDS to place the call. It's just a prohibition without consent. So it's important you understand those state laws that we really just don't have time to go through in today's presentation. Also, this issue of vicarious liability. There's a case out there that the FTC initiated against Dish Network that gives a really good background on how somebody can be vicariously liable for the calls that their telemarketers make on their behalf. Just understand there is no strict or direct liability for what your telemarketers do on your behalf, but what the FCC is going to look at is whether there's an agency theory. They look at the common law. The common law theory of agency to determine if you've given somebody the ability to make calls on your behalf. Generally in the case law, we're looking at, can they make sales on your behalf? Are they using your name? Do they have access to your sales systems? Those types of things would tend to lend themselves to an agency theory. Contractual relationships, while not controlling, are important. So if you're using a telemarketer, it's worth that ounce of prevention to have an attorney take a look at that relationship and see if there's a way that you can limit agency liability while also making sure that they're making compliant calls on your behalf. VoIP numbers I wanted to bring up because the prohibition in the TCPA is actually a prohibition against calling cell phones, hospitals, some other types of calls, but also calls for which the called party is charged. There are VoIP services out there that charge a nominal amount, 3 cents per call, including if just if a voicemail message is left on that VoIP system. So technically, you have violated the TCPA if you call a VoIP line for which that called party is charged. The irony of the fact that you have no way of knowing that that person is charged does not escape anybody, but still there is liability there. The only, if you could call it a silver lining, is that trebling for willful calls that I talked about from 500 to 1,500 doesn't happen here because it's not willful that you have called somebody at a number for which they are charged. So it's only a $500 violation, which is less and less likely to be class action. But if you make 20, 30 calls to one of these VoIP numbers, that 500 multiplier again becomes somewhat significant. You can scrub against VoIP phone numbers. There are services out there, probably worth the investment to look at something like that. So as you're doing your do not call scrubbing and your cell phone scrubbing, reassigned number scrubbing, you can also look into VoIP number scrubbing. The reassigned or wrong number issue, as I said, it's really about training. Here's some mitigation strategies. Make sure you're updating your customer records. Use those third-party scrubbing services that are available out there. And if you're in a high-risk area like debt collection, highly recommend that cell phone numbers are called using a manual dialing system. Also, I will tell you that if I had $1 for every time one of my clients or potential clients told me that they could call somebody without worrying about it because they had purchased opt-in leads, I would be a very wealthy woman. And as soon as someone tells me that they were sold opt-in leads, I am confident that there was no opt-in that happened, because an opt-in lead is very difficult because you guys know that if you're going to make a telemarketing call, you need prior express written consent to you. It's got to specifically identify the seller. And I have yet to find a lead generator that generated a lead for just these buying opt-in leads kind of generally that specifically identified that seller. So there are all kinds of ways that we can use lead generators, and there's some very good ones out there, but just be leery of this term opt-in. Also, buying lists with no cell phone numbers. Make sure you're doing the scrubbing on your own unless you're confident that the vendor's doing it. Multi-purpose forms. The issue with those is, let's say that we're using a form to consummate a sale. So it's a sales contract, and then buried in that sales contract is consent language, so that you're saying by signing this, you're giving me consent to call you. The regulators and the courts have a lot of trouble if you're signing to consummate a sale and also to get consent to call somebody. So there are ways you can do it, but just understand that that type of thing can be an issue. You know, the affirmative consent, we've talked about it, and adequate and conspicuous disclosures. You can't bury it in your privacy policy. So again, this is an area where it's worth having somebody review not only that your system is not an ATDS, but if you are relying on consent and using an ATDS, get somebody to look at your consent. As far as risk mitigation goes, we've talked about vendor and lead generation due diligence. Really understand what people are doing on your behalf. Make sure they have good compliance mechanisms built in. And then within your organization, centralized compliance, you know, you're already required to have a compliance officer for the red flags rules and for other statutory requirements. So if you centralize this compliance function, maybe within that person or somebody within your marketing department, it is a good way to go. Although I will tell you, your compliance folks should probably not report to your sales folks. There's typically a conflict of interest there, so generally compliance should be outside of sales. If you are exempt from any of these regulations, make sure you have good documentation that's not an ATDS or that some other exemption applied, maybe an emergency exception if you're providing recall notices. And those are for the safety and health of the person that you are calling. You could have an emergency exemption there. Training, monitoring, reporting, recurring audits, all best practices for compliance. All right, so we've talked about the other things. I appreciate you being at the presentation today, and I'm happy to have been here with you, and if I can assist you in the future, don't hesitate to contact me. Thank you.